joining us on our latest webinar of our payroll series, which today focuses on some potential payroll-related HR scenarios. My name is Grant Saunders, Payroll Service Development Director here at Azets, and for today's presentation, I'm joined by Head of HR Consultancy Services, Hannah-Jane Dobby, and Senior HR Consultant, Sam Aldridge. In our previous webinars, we've discussed some of the benefits of payroll outsourcing, the importance of the data held within payroll in terms of accuracy and security, and more recently, we've looked at employment tax implications within your payroll function. Today, we're going to move on to a number of key areas which relate to HR and how these can have an implication on your payroll administration. So we'll be looking at the following subjects that you can now see on your screen. So without running through everything, we'll be looking at taking on your first employee, the things that you need to do to get that set up. And then there's some sort of hot subjects at the moment in terms of termination reasons and termination payments and hybrid workings on that list as well. We'll try to make today's presentation as interactive as possible by conducting a few poll questions for you. Very simple to do. During the webinar, the questions will pop up on screen and you just need to select your answer when prompted. Before we do kick off, just a couple of housekeeping points. We plan for the webinar to last no longer than an hour, and that's taking into account a Q&A session at the end of the presentation. And if you do have any questions, you can raise these throughout the webinar via your dedicated control panel on the right-hand side of the screen. If you do have any questions that we do not get around to addressing during the session, we will attempt to respond to these later. Alternatively, please get in touch with either myself, Hannah-Jane or Sam, or another member of our Azets team directly. So before we get started, I'd like to introduce my co-presenters. As I mentioned, today I'm joined by Hannah-Jane Dobby and Sam Aldridge from our HR consultancy team, who work very closely with our payroll team here at Azets. I'm now going to hand over to Hannah-Jane, who will kick things off with our first poll question of the presentation.
So thank you for the introduction, Grant. Sam and I are delighted to be here with you on the webinar today. So the first poll question for today, very simple one hopefully, is your current HR provision in-house or outsourced? Or perhaps you don't have an HR provision. So if you could select in-house, outsourced or no HR provision. Appreciate some of you may use a combination of these. Maybe you have somebody in-house at a lower level and outsource more complex issues, but if you can select the one which applies most to you. Okay, so is your current HR provision in-house, outsourced or no HR provision? And hopefully we'll have the results in just a moment. Okay, so quite a large percentage of you do have in-house HR provision at some level or another, but about just under 20% with no HR provision and 20% outsourced. So that's interesting to note. Thank you. So once again, thank you for the introduction, Grant. Sam and I will now take you through a few typical HR scenarios that you might be faced with. Some more regularly than others, but hopefully all relevant to you as employers. Hopefully at least some of these situations will be ones that you can relate to, even if you actually haven't had to deal with them yourselves. So Sam.
The first scenario then, Hannah-Jane, so my husband and I run a small IT consultancy business together. We're thinking of the future, we're succession planning, we're getting busier and busier. We're thinking of recruiting someone, but at this stage we're not sure how often we're going to need somebody or for how long there'll be enough work for them. What do you suggest that we do?
Well, I think first things first, you need to decide whether you want to take on an employee and have them on your payroll, or whether a consultancy or a contractor arrangement might work better for you. Do you want a contract of services or a contract for services? Whichever option you choose, we need to consider employment status. Is the person an employee, a worker, or a genuinely self-employed individual? And the contract will need to reflect the reality of that situation rather than what you might like to be the case. I can certainly help you consider the type of working arrangement that might fit best with what you're looking for. Employees have the most rights. Workers have only basic rights, and contractors have no employment rights if they're self-employed. Same for the common law duties, obviously, of health and safety and their right to be able to carry out their work in a safe environment, one free from harassment and bullying. If you go down the contractor route, there are employment status checks to consider, and also IR35 implications if you are a medium or large end user. That doesn't apply to you from what you said, but if you're not sure how often you will need someone or how long there will be enough work for them, then the contractor route is an option to consider. Alternatively, you could consider a temporary or a fixed term contract with a view to extending this or making it permanent when you better know what you need.
Okay, so I think that sounds like a good option. I think we're ready to employ somebody.
So you'll need to think about recruiting and selecting your candidate, a job description and/or a person specification, what you'll cover at the interview, and how you will determine the right candidate. You have to be careful there's no discrimination that could be claimed.
Okay, I think we're all okay with that part of it.
So, as well as registering a PAYE scheme with HMRC, you'll have to issue your new employee with a contract, or at least meet the minimal legal requirements of the Employment Rights Act by giving them a written statement of particulars. And employees are now entitled to this from day one of employment. Some employees are unlikely to want to resign from their current role, however, if they haven't seen a copy of a contract. So it's actually best practice to have one in advance of day one. You'll also need to decide what kind of contract is appropriate. A standard contract for full or part-time hours, a fixed term contract for a set period of time, a temporary contract, or a 0 hours contract where someone has no set hours but can be available to work when requested, with or without the right to refuse, depending on the nature of the employment relationship. Do bear in mind some types of contracts will automatically become permanent after a period of time though, regardless. Your employee will also have some day one rights, and you'll need to determine provisions for pay, ensuring you comply with the national minimum wage requirements. You'll also need to consider pensions in line with auto-enrolment, sick pay, holiday entitlement, notice periods. Will there be a probationary period? What business protection do you want to achieve? Maybe restrictive covenants, any intellectual property provisions or confidentiality clauses.
Great, thank you very much. Is there anything else that we should be thinking about at this stage?
So you'll also need to think about any background checks that they might need, such as references, DBS criminal record checks, as well as obviously employment references. And other considerations will of course include checking the employee's right to work in the UK and providing some kind of induction.
Okay, is there anything else aside from contracts?
You will need to ensure that you have the legally required policies in place from day one or within 8 weeks of your employee joining, as well as taking data protection into account and ideally having a data protection notice drawn up to cover this.
Okay, great. And what parts can Azets help me with all of the above?
So we can draft offer letters, legally compliant contracts, and indeed consultancy agreements if needed. We can help ensure that you cover off all the legally required aspects under the Employment Rights Act, and of course draft the necessary business protection clauses to suit the needs of your business. We know one size doesn't fit all. We can assist with preparing for interviews. We offer psychometric tests if they were ever necessary to help with your selection process. We can draft job descriptions, design inductions, and once your employees started, we can also help you look at assessing suitability and performance during their notice periods.
Great, thank you.
So we have another poll question for you now. According to the Azets SME Barometer from spring 2022, 2/3 of SMEs found that recruiting new talent with the right skills was challenging. So do you agree with this? 2/3 of SMEs find recruiting new talent with the right skills challenging. So agree, disagree, or don't know. So I'll just give you a moment or two to select your answer. And then we can see what the results are. Okay, that's very interesting and certainly supports the results of the SME Barometer. It's certainly been a scenario many of our HR clients are facing, so it's interesting to see that, that this is applying to you as well. We haven't got the time to cover this one off in too much detail today, but there are certainly a number of things employers can consider, such as widening the pool of potential applicants, reviewing salary benefits, and of course embracing hybrid or flexible working, which we will come on to later. So thank you for that. So Sam, I have a scenario for you now. I run a small business. One of my employees is off on long-term sick leave. I haven't done anything about it yet, except just keep paying them, but what should I be doing?
Okay, so first of all, what you pay someone when they're on sick leave will depend on what's in their employment contract regarding sick pay and their entitlement to statutory sick pay. So it's fine to keep paying them on full pay, which is effectively contractual sick pay, but you must ensure that you're consistent in your approach to all employees, and that you don't inadvertently set a precedent that you don't want to keep or that you can't keep up with, and also that there's no possible liability for a discrimination claim. So there can, of course, be exceptions to sick pay for individuals, and that would be by company discretion. But it's vital that you have clear contractual terms or a policy setting out when contractual sick pay applies and for how long. That's if you're going to pay contractual sick pay.
So how long do I have to continue to pay them?
So it depends what the terms are. Statutory sick pay is payable for up to 28 weeks. When paying contractual sick pay, it is usual that statutory sick pay is topped up to a full pay for a number of weeks before it goes to just statutory sick pay. But if you do it this way, then the 28 weeks entitlement begins from day one. It's important that those on long-term sick leave, you gain a better understanding of their health and if and when they may be able to return to work, if they're ever able to return to work. So we would suggest that the first step with long-term sickness absence is to thoroughly investigate the situation to help you understand the current and future prospects of whether the employee is able to return to work. And we would recommend gaining medical opinion on this. You can instruct an occupational health advisor, but in the first instance, it may be more appropriate to approach a GP, the employee's GP, but this can only be done with the employee's consent. So once you have medical opinion, these can provide information on current and future capability to return to work, but it can also assist you by implementing some temporary reasonable adjustments to aid their return. Once you've received the medical opinion, you're better placed to decide on the next steps. So finally, dismissal is possible for employees on long-term sick leave, but it's a very important area to get right, and you must be mindful of whether the employee is considered to have a disability under employment law. A fair process must be followed, and it's important to get advice on this one.
Okay, so what do you mean by disability under employment law? Is a disability not just a disability?
No. Under employment law, someone is considered to be disabled if they have a physical or mental impairment that has a substantial and long-term negative effect on their ability to do normal daily activities. So the Equality Act 2010 provides protection for employees from being discriminated against because of a disability, but you have, and this is just because you have protection under employment law, it doesn't mean that you'll be classed as disabled for other things such as claiming benefits.
Okay, well, I didn't know that. So what assistance can Azets provide me with on this matter?
So we can advise on the individual situation once we have more information, and we can help draft the necessary letters, including requesting consent from the employee and requesting the medical reports. We can guide you on every step of the process, and if necessary, we can facilitate organising an occupational health appointment for the employee.
Brilliant, thanks, Sam.
So, on to the next poll question. So this poll question, it states that 1 in 5 businesses are said to be considering terminations within the next year. Is this something that your business is planning? If you can please select an answer, it's yes, no, or don't know. I'm just going to wait a few moments for you to select your answer, and then we'll have a look at the results. Shouldn't be too much longer. No, okay. So only 7% of you have said that you are, so that's less than the average. So this 1 in 5 businesses, this came from ACAS. However, Bloomberg have also said that the same, that 1 in 5 businesses are considering redundancies in the next 12 months. So it's really interesting that 71% of you don't, but 22% don't know. So perhaps this may apply to very large organisations, or perhaps it's just too early in the financial year to know at this stage. So thank you. Moving on to the next scenario, I'm going to ask you, Hannah Jane. So what do I need to pay an employee who I've just dismissed?
Well, I think my first question has to be, what is the reason for dismissal? There are only, in fact, 5 fair reasons for dismissal. So which one of these is it? So the first one is conduct or performance. The second is capability, which will include ill health. The third one is redundancy. The fourth one is a statutory restriction, so the employee is no longer entitled to work in the UK, or, for example, a driver is no longer legally able to drive, and driving is an intrinsic part of his role. Or the fifth one, which is some other substantial reason. So maybe for use when the continued employment of an employee could result in you losing business, a breakdown of trust and confidence between you and the employee, maybe a client who has insisted that the employee is dismissed or they're going to take their business elsewhere, maybe someone's arrested and that could cause you issue for your business, or potentially also if an employee has unreasonably refused to accept some kind of company reorganisation or a subsequent change to their terms and conditions. So which one of those reasons is it?
So we have dismissed for ongoing poor performance.
Okay, that's quite a common one. What length of service does your employee have?
I think it's about 5.5 years, but why is that important?
Well, only employees with more than 2 complete years of service with you can claim unfair dismissal. So it's even more important once they have more than 2 years service to follow proper process.
I think we have followed proper process, but what should we have done, just to check?
Well, in order for a dismissal to be fair, as you've already identified, proper process should be followed. And by proper process, I mean your own policies and procedures, and also the ACAS Code of Practice on disciplinary and grievance. So have you, for example, investigated the matter and been through a number of disciplinary hearings with formal invitations, the right to be accompanied, and you've given the employee a fair chance to improve? I only mention this as if you do not follow the right process and a claim is made for unfair dismissal, then any award made at a tribunal, should it get that far, can be uplifted by as much as 25% if you haven't followed the ACAS Code of Practice.
Okay, so we might not have done things exactly as we should have done, but we have to end this now. So we just need to know what we have to do to pay them for the employee to go.
Well, there is a risk of unfair dismissal, but for now, let's just deal with the payment and ensure that we limit the potential claims that could be brought. Although there are some statutory obligations to adhere to, what you need to pay very much depends on what's in your contract. So it'd be useful to see a copy of your contract with regards to holiday and notice periods, and if you have the contractual right to make a payment in lieu of notice if you want the employee to leave straight away. So you want to avoid any potential wrongful dismissal and an unlawful deduction of wages claim. So again, I'll check your contractual notice against the required statutory notice that this chap may be entitled to.
So for future reference, should I involve you sooner in this? And I suppose when should I have involved you?
Well, I think in a situation like this, the sooner we are involved in something, then the easier it is to ensure the situation's managed properly, and the sooner we can actually start to take away your headache. We can be involved as little or as much as you need us to be. We can advise from afar, we can help conduct investigations, be on hand for queries. We can even attend hearings with you, either as the HR representative or indeed chairing them. We can provide or prepare and provide aid memoirs and scripts, draft the letters, and we can also draft settlement agreements should that be something that you need to consider.
Great, thank you.
So coming on to another one for you, Sam. I work in the hospitality industry, and we usually pay overtime to our staff as long as it's agreed overtime and it's all agreed up front. I've now got a lady who's reducing her hours from next month, and she'll only be working 3 days a week when she returns from her adoption leave. How will overtime work for her now that she's part-time?
So for part-time employees, well, this very much depends on the contractual terms of overtime or any overtime policy that you have. Legislation protects part-time employees from being treated less favourably than full-time employees, so that's something to be mindful of throughout. If your overtime terms provide that any employee who works above their contracted hours receives overtime pay at a different rate, then if she works above her hours, for example, in this situation, if she works above 3 days, she would also be entitled to overtime pay at this higher rate. The difference is if your policy states that overtime pay only applies at certain times, This could be, for example, unsociable hours or at weekends. Then this would also apply to part-time staff in the same way. So if she worked an additional day during the week, then she would only be entitled to payment at her usual rate of pay, as this falls outside of when your overtime rates actually apply. So generally, unless the policy or contract states otherwise, you don't have to pay overtime at an increased rate to a part-time employee until they've worked the same number of hours as a full-time employee. But it's important that you ensure that your overtime terms are clear and that the part-time employees are not subject to less favourable treatment.
Okay, great. So can you help me with what I need to do?
So what we would need to do is look at your overtime situation and how you'd want it to apply. We need to check the contractual clauses and any overtime policy to advise on this particular occasion, and then we can advise on how they should be updated for the future if required.
Okay, great, thank you.
So a scenario for you, back to you. So I have accidentally overpaid an employee. Number one, can I get my money back? And number two, can I just deduct it from the next salary payment that I make?
Yes, potentially, but once again, Sam, it does depend on what you have in your contract. You want to avoid an unlawful deduction of wages claim. However, with the right wording in your contract, you are usually able to reclaim any monies overpaid to an employee. You need to ensure that the monies were overpaid in error or are genuinely monies owing to you. You need to ensure that the deduction has been communicated to the employee and that it is written into the contract as specifically as possible that monies can be deducted and under what circumstances. So the contract clause I'm referring to will usually include some kind of provisions for deductions above a certain amount to be notified to you first. And it may also detail the situation where there's not enough money in the employee's final salary payment to make good on the monies before they leave. You might agree that if it's a large overpayment that you've made, or indeed a large sum owing, that it's split across a number of months to avoid causing the employee financial hardship.
Okay, so if it is something large, like a training cost, would you recommend having an agreement in place so that if we pay for something on behalf of an employee, we can deduct it from their salary if they, for example, left the employment?
Yeah, absolutely. So you need to ensure that you can rely on the terms of any loan agreement or training clawback cost agreement, as well as what's in your contract. So I would want to have a look at your contract and any additional agreement that you had in place for advising in full on this. So just so you know, we can draft any of these types of agreements for you if you need one. We are, after all, here to help take away your HR headaches.
Great, thank you.
And we move on to our final poll question for today's session. So this one is with regards to hybrid working arrangements, obviously quite a hot topic in both the HR world and the commercial world at the moment. So the question is, do you consider hybrid working arrangements important for attracting and retaining talent? So the answers are on your screen: yes, no, or don't know. Do you consider hybrid working arrangements important for attracting and retaining talent? I'll just give you a couple more seconds to select your answers, and then we'll see what this looks like. Okay, so it seems a large proportion, so almost 75% of you that do consider hybrid working arrangements important. And I think taking into account the fact that everybody is struggling to attract and retain talent at the moment, it is looking at all those alternative ways of ensuring that you can do so. And certainly we are aware now from talks with recruitment agencies where people will not consider a job unless there is at least one day, maybe 2 days a week working from home. There is some kind of hybrid or flexible working arrangement in place. So I think this supports very much what we're experiencing and what we're inviting clients to comment on, and indeed what we're dealing with our clients. So thank you for that. So that takes us nicely on to the next scenario, Sam. We are looking at hybrid working for our employees and asking them to attend the office now for a set number of days. So how do I go about this, and how do I deal perhaps with an employee who maybe doesn't want to return to the office, or perhaps not as regularly as I'd like them to?
So firstly, I would suggest that a consultation takes place regarding the proposed contract variation, and this is if the employees were either full-time office-based or full-time home-based previously, and you're now looking for a hybrid working arrangement. Perhaps you might have done a contract variation during lockdown to show that they were home-based. But ideally, you should hold a meeting where you propose the new working arrangements going forward and you invite questions or comments from the employees. So you should then confirm this in writing and aim to ensure that you have a meaningful consultation period, reflect on the issues that they raise and consider any possible changes that you might have to your proposals. So the consultation process is really useful to gauge employees' views and for you to be made aware about any concerns or considerations that they have regarding the new working pattern. And normally you can usually work together to try to come to the best solution. If somebody refuses to return to the office, you would require a discussion with them to find out why. They can refuse to return to the office when they have reasonable belief that it poses a risk of serious and imminent danger, usually to their health and safety, but this would require some delicate conversations regarding their concerns and what information you could provide to alleviate those concerns. If this is not the case and the employee is refusing to return to the office, they could face disciplinary action. But I would caveat this with that there's normally going to be a number of conversations that take place prior to this to determine the reasons why and any possible alternatives. For example, they could submit a flexible working request if they wanted to amend their working arrangements. And in regards to the consultation period, I would normally say that you should provide reasonable notice of the request to return to the office and set any contract variations in writing.
Okay, thank you for that. So you mentioned there that someone could put in a flexible work request. So how would that change the situation?
So if somebody makes a formal flexible working request, then this has to be given proper consideration. And there's actually only a few reasons why a employer can reject a flexible working request, and it's getting harder and harder to be able to justify some of these now. There is a set process to follow. You have to have some meetings, there's timelines, and there is also a right of appeal if the outcome is not what the employee had hoped for. An employee currently has to have 26 weeks service in order to make a statutory flexible working request, but this might actually be changing soon.
Okay, so what advice can you at Azets provide me to help me navigate a particular situation like this?
So we would probably want to discuss with you your office attendance strategy in more detail and determine what you want and what you need to achieve. If you'll look at holding a consultation process, then we can also help manage that for you. We can deal with the necessary consultation and contract variation letters. If you needed assistance with managing any flexible working requests, then we can also help with that too. Pretty much anything that you would expect from an internal HR department, we can offer to help you with.
Great, thanks, Sam.
So I think, yeah, back to you. I have a lady on maternity leave, but we're coming to the end of the year, and this is when we do our annual pay review and our bonus considerations. So is this lady who's on maternity leave, still entitled to a pay rise and a bonus?
This is always an interesting one. The answer is going to be yes to a pay rise, as you can't discriminate against someone and not give them an increase just because they're pregnant or on maternity leave, not least as pregnancy, maternity and sex are protected characteristics. But with the bonus issue, there are a number of things to consider, such as whether it is discretionary or contractual, the actual terms of the bonus scheme, the criteria, and also the timing of the award. So I'll take the pay question first. Following the well-known Alabaster case of Alabaster versus Barclays Bank back in 2004, it was determined that maternity pay calculations need to take into account any pay rises effective between the start of the statutory maternity pay calculation period, so not just the start of the maternity pay period, and the end of the statutory maternity leave. Our maternity pay regulations were updated the following year, so that if one or more pay rises were awarded at any point during this period, then the maternity pay calculations will need to be recalculated, taking the new higher earnings into account and the difference paid. This may, of course, include more than one pay increase, as the relevant period could be up to a 17-month period. You'll also need to consider any increase awarded after the maternity leave period ended, but which is backdated to a date within that period. Similarly, if you pay national minimum wage, you will also be required to review the average pay calculations when the national minimum wage increases, go back and again apply this increase. Bonus awards cannot discriminate and also need careful handling when it comes to maternity leave. But what sort of bonus are we talking about here, Sam?
So we're looking to pay a Christmas bonus to all employees, and also an end of year bonus, which is based on company and individual performances. And this is before the pay rises take effect on the 1st of January.
Okay, the Christmas bonus is easy, as it is a bonus that applies to all. You can't treat someone different because they're on maternity leave, we've already said. We can't treat them less favourably, and so this bonus will still be payable to this lady in its entirety. A discretionary loyalty bonus would also be treated in the same way if it wasn't based on attendance. With regards to a bonus based on company and/or individual performance, this is slightly more complex, and it also depends on when the bonus was accrued. So was it before they went on maternity leave or during? A woman on maternity leave remains entitled to all her contractual benefits while on maternity leave, save for those relating to salary, which would include a contractual bonus. However, if it is a contractual bonus, it should at least take into account three things. The first is the time in that bonus year before she went on maternity leave, the 2 or 4 weeks, depending on your environment, compulsory maternity leave that the lady had to take, and the period after she returns to work from maternity leave, including any time taken as holiday, as long as that's still within that same bonus calculation period. Bonuses for those on maternity should still be paid at the same time as all other bonuses. If the bonus is discretionary and dependent on either attendance or individual performance, it should again be prorated based on the times that I've already mentioned. So the time before maternity leave, the 2 or 4 weeks compulsory maternity leave, and the period after the return from maternity leave, including that taken as holiday.
Great, thank you.
And I think this is the final question I've got for you, Sam. How do I calculate holiday entitlement and holiday pay, especially for someone with no fixed hours?
Okay, so just talking generally about holiday entitlement and holiday pay, and then we'll move on to those with no fixed hours. So holiday is calculated differently for employees depending on the type of contract that they have and their working arrangements. So the basic rule is that full-time employees and workers are entitled to the statutory minimum of 28 days or 5.6 weeks a year, which can include bank holidays. For those who work full-time, it's easy as they receive 28 days or whatever additional entitlement that you offer. It's slightly more complicated if they work condensed hours. This would be longer shifts but on fewer days, but essentially they're entitled to the same number of days where a day is equal to whatever they normally worked on that day. Part-time entitlement can be calculated based on a pro rata number of days or hours as the full-time equivalent. And bank holidays that fall on working days can count towards holiday entitlement, but this depends on what's in the contracts. But there's no legal entitlement to bank holidays as holiday. So those workers with no fixed hours are still entitled to a pro rata amount of the 5.6 weeks holiday each year, or more if you offer more. What you could do is you could use the 12.07% calculation if this holiday entitlement is statutory minimum, and this is whereby you calculate the number of hours holiday a worker has accrued based on the number of hours that they've worked, and you multiply this by 12.07%. Again, sorry, if you offer more than 28 days, then this percentage calculation would need to increase to cater for that. So there are limitations with the 12.07% calculation method. It only applies to statutory holiday unless you increase that percentage, or it's not suitable for certain types of working arrangements, and this includes term time contracts, for example. It doesn't work for those types of working arrangements. So the way that holiday pay is calculated is based on the average of 52 weeks pay. And this holiday pay includes things like regular or guaranteed overtime, any bonus, any commissions. It's not just salary. So an employee should get the same wages when they're on holiday that they might expect to get when they are working. And the aim of this is under the working time legislation that governs this, which is encouraging all workers to take adequate time off and not be penalised for doing so.
So what about someone who works on a 0 hours contract who just wants to be paid their holiday? Can we do that?
So holiday calculation and holiday pay are two separate things. To traditional rolled up holiday pay, which is where you increase someone's hourly rate in effect as payment for holiday. So that just their usual hourly rate is more than what they would normally get. This is technically unlawful, but the UK has never actually put in place legislation prohibiting the use of rolled up holiday pay. So whilst we would not encourage doing this, as long as the holiday pay has a separate and distinct line on the payslip and entitlement is calculated properly, this can be seen as acceptable. If you use the 12.07% method to calculate holiday for a 0 hours worker, they can be paid on an annual or quarterly or monthly basis for holiday, just as long as it's calculated properly and it's shown separately as a payment for holiday on their payslip. And many 0 hours employees welcome having extra pay rather than being forced to take time off.
Great. So could you help me with the calculations for my employees?
Yep, no problem. We have some holiday calculators that we use, and we can also work through all of your employees to ensure that they get the correct entitlement to holiday and that they're being paid based on the right calculations as well.
Brilliant, that's been really helpful. Thanks, Sam.
Yeah, thank you. Thank you very much.
So we hope that served as a useful overview of a number of different HR related topics. And we'd just like to finish off our presentation part of this session with a few pieces of upcoming legislation, as I say, before we move to taking any questions.
So just looking at this list here, we're just going to briefly run through them. So I'll just deal with the first few. So there is going to be an upcoming extension to flexible working, which is a topic that we mentioned earlier. The proposal is that flexible working will become a day one right rather than requiring the employee to have 26 weeks service in order to make a request. So they'll be able to make a request sooner. Carers leave. So there's a new provision for carers leave coming in. It'll be introduced as soon as parliamentary time allows. And the proposal is to give all employees a week of unpaid leave each year to provide care to disabled, older or ill relatives and friends. Increased break in continuous employment, which is the third one in that list. So currently employees only have to have a break of 1 full week in order for continuous employment service to be broken. But this is looking to be extended from 1 week to 4 weeks. So it would need to be 4 weeks break in service. Right to work checks. So this was temporarily changed as part of COVID, but it's obviously worked because the government has now put a permanent system of digital right to work checks, which will replace the temporary COVID measures that were already in place. And sexual harassment, which is the final one that I'm going to deal with. So a duty requiring employees to prevent sexual harassment will be introduced, and this includes explicit protections from third-party harassment. So the time limit for bringing related claims will be looked at possibly being extended to 6 months as well. So HJ, I'll hand over to you for the last few.
Thank you, and just the last couple. So redundancy protection for new parents is also proposed to be extended. So the redundancy protection period will apply from the point that the employee informs the employer that she is pregnant, whether this is verbally or in writing, and it will extend the redundancy protection period for 6 months after a new mother has returned to work. The same will also apply for adoption and shared parental leave where applicable. And as Sam's just mentioned, with the sexual harassment and the potential time frame for claims being extended to 6 months, it's proposed also that the time period for claims relating to redundancy and discrimination, so on the grounds of pregnancy or maternity, would also be increased again to 6 months. And lastly, this is the right for all workers to request a more predictable and stable contract after 26 weeks of service. So this is a proposed new law which will introduce exactly that, a right for all workers to request a more predictable and stable contract after 26 weeks service, and requiring compensation for shifts cancelled at short notice. So this is going to be particularly applicable to those on 0-hour contracts or fixed term contracts or temporary contracts. So we hope you found our webinar informative and insightful. I'd now like to invite Grant back to join us as we tackle some of the questions that have been sent to us. Please do use your control panels to pose any further questions if you have not already done so.
Great, thanks Hannah Jane, thanks Sam, that was a really good presentation. I have just seen one question from somebody who said they were desperately trying to make notes throughout, so don't panic. We will be sending out a copy of the slide deck from today's presentation, so that will be in your inbox hopefully later today, so don't panic on that front. Yeah, so we have had some questions come through for you guys. I'll just fire them across and see which one of you wants to answer. When I am terminating an employee, why do I need to look at contractual notice periods and statutory notice periods? Will the contract not always be right?
Shall I take this one, Sam? Okay, so most employees have a contractual notice period detailed in their contract, and just say, for example, that is a contractual notice period of 1 month. If your employee has been with you for 5 or 6 years or even longer, then actually there is a statutory notice provision which will exceed that which is in the contract, because the statutory notice, once you've got a certain number of years of service, actually goes up 1 week per year of service up to a maximum of 12 weeks. So if your contract says 1 month, but you've been with your employer for 6 years, then actually the statutory notice period of 6 weeks would be longer, and therefore that would override the contractual notice.
Excellent, thank you. Can I dismiss someone in their probationary period without following a disciplinary procedure?
Are you looking at, shall I do this one?
Yes.
Okay, so you may be able to not follow a full disciplinary procedure, but this is only if your disciplinary procedure policy or if your contract allows to do so. Otherwise, you may need to follow a full disciplinary process. I mean, you would still need to hold a certain number of meetings, and during their probationary period, you have an obligation to ensure that they have sufficient training and that they've been given a bit of time to improve if there's issues with performance, but you don't necessarily have to follow a full disciplinary procedure during a probationary period. You should always consider if there's any additional considerations, such as a possible claim for discrimination or a wrongful dismissal because there is no length of service. So unfair dismissal requires 2 years service, but there's possibly no length of service for a discrimination claim. So you must always consider whether there's any possible potential claims in that area.
Great, thank you. Do I have to pay company sick pay over and above SSP? What is considered normal?
I'll take this one as that was my scenario. No, there is no legal obligation to pay anything over and above statutory sick pay, but because statutory sick pay doesn't kick in until day 4 of a continuous period of sickness, a lot of companies do opt to pay some form of company sick pay. As I say, there's absolutely no legal obligation to do that. It's very common in some industries that statutory sick pay only is paid. For example, sort of hospitality, tourism, very typical. I would say I have this discussion with clients on a reasonably regular basis as to what constitutes fair and reasonable contractual or company sick pay. Some pay 5 days in a rolling 12 months, others maybe 10. Others will have a very large provision and maybe pay for 3 months or even up to 6 months of full pay, or a combination of full pay and half pay. So there's no right or wrong with this. I think it's just really, it's a commercial decision in terms of what the business can afford and what it needs to take into consideration. Maybe the types of absences that you come across, whether they tend to be lots of short-term absences or sort of more long-term absences, because again, the treatment of those might be slightly different. I think Sam made the point earlier about ensuring that you're consistent and not inadvertently setting precedents. So I think my advice would be to always put into the contract, or at least into your policy, a number of days if that's what you intend to pay, because actually custom and practice would override what was written in the contract. So for example, if you state that you only pay statutory sick pay, but over the course of a couple of years, you know, you've constantly been paying all of your employees full pay when they're off sick, actually that would become custom and practice and would override what was actually written into the contract. So yeah, 1 or 2 things just to look out for on that one as well, I think.
Amazing, thank you. We've had a couple of questions on holiday pay, so I think there's a bit of confusion. Is rolled up holiday pay still allowed, or is it now illegal?
It's technically unlawful, and case law determined that it was supposed to be unlawful. However, as Sam said earlier, the UK didn't actually ever bring in any legislation which made rolled up holiday pay unlawful. What is unlawful is to add in holiday pay to somebody's hourly rate and just pay them, you know, £9.50 an hour instead of £8.50 an hour, so that that in effect accounts for holiday. Using that 12.07% calculation, yes, it's one of those things that takes a while to get your head around, because that is how you calculate the amount of holiday entitlement rather than actually what you're paying somebody. But as Sam outlined earlier, as long as you are distinguishing holiday pay on the payslip and it's quite obvious that a payment is being made in lieu of holiday being taken, then it is something which is still accepted. The gov.uk website says that they actively discourage rolled up holiday pay, and if that's what you're doing, you should review your policy on that. But I think with 0 hours workers being such a thing now, using that method of holiday pay and indeed calculation can be really useful. So hopefully that sort of explains that a little bit better and unravels the confusion there.
Great, thank you. You mentioned disability. How do I know if my employee has a disability and what counts as a disability?
Do you want to say that one?
I'll start off, HJ. So the definition is legal, not medical. So certain conditions automatically apply under the definition of under the employment law. There are some conditions such as cancer, for example, automatically is considered a disability. So it's important to remember that you should also consider mental impairments, so not just physical impairments. The way that you might know, you may be told by the employee themselves. Which is, you know, if they request reasonable adjustments or something like that to their working arrangements, then you would obviously know that they've got a disability. But a tribunal would also consider whether you ought to have known based on the facts, even if you don't, if you haven't been told. So it can be quite difficult in the situation. So sorry. HJ, unless you have anything to add on that.
No, I think no, you're absolutely right, and I think, you know, there are a number of conditions which are automatically covered from day one, and cancer, as horrible a topic as it is something which is covered from day one. And even if you are in remission, and or for other conditions like MS, HIV, they are automatically covered from day one as well, and visual impairment, so somebody who's blind or partially sighted. And actually, if you have a condition, even if that condition can be managed by medication, then it still classes as a disability, because you have to consider the effect that if you remove the medication, that person would still suffer, you know, on that sort of on the basis as outlined in the definition. So it is one that causes a lot of confusion, because things that are classed under the law as a disability aren't necessarily the things that we would look at and see. You know, for example, people always say, well, if I've got a disability, well, I haven't got a blue badge, or vice versa. And as Sam's already alluded to, yeah, it's the legal definition of a disability under the Equalities Act, rather than a medical decision or a medical definition. So
Great, thank you guys. We provide accommodation for our employees who make some contribution towards the cost. Should this contribution be pre or post tax?
That's probably one which actually falls slightly outside of our remit, and is one that we would probably refer to the employment tax team, because it does depend on the nature of the accommodation, for what reason the person is in that accommodation, whether they actually need to be on site and for how much of that time. So it's one where we would want to look at the contracts and see what was actually written in there about the requirement to be on site. And then I think once we determined that, we could look at the taxation side of it, and that would be in conjunction with our colleagues in the employment tax team.
Great, thank you. And how do I handle a situation where I have an employee who will not return to the workplace even now? So I assume that means following lockdown and COVID.
Sam, do you want to take that one, because you were dealing with my employee who wouldn't return to the office?
Yeah, I mean, I think from my perspective, initially I would have a conversation with the employee to find out the reasons why. It could be a number of different things, and I think normally these types of discussions can normally resolve it so that you can figure out what the actual obstacles are to returning and how you might be able to help alleviate them. And again, I mean, I think I said this in the answer previously, so sorry to repeat this slightly, but they could also make a flexible working request to permanently change their place of work, which is something that you can make under statutory flexible working request, which would mean that it would need to be properly considered. So I think initially I would just hold a few conversations to establish the reasons why and see if you can come to some sort of agreement between you. Otherwise, the person has the option to make a statutory flexible working request, which must be considered. And I don't know whether you have anything to add to that, HJ?
No, I think it's just as, reiterating that actually if you do have somebody who is unreasonably refusing to return to the workplace and that is their base location, then yes, you can take more formal action, but you do need to try and consider all of those alternatives before you move to dismissing an employee. And that might be one of some of the substantial reasons that I mentioned as one of the 5 fair reasons for dismissal in a situation like that, potentially.
Okay.
Excellent, thank you. Another one's come through. Redundancy once an employee is returned from maternity pay. Are you indicating that you cannot make someone redundant within the first 6 months of their return?
The new statutory legislation has not been published in great detail, but that provision of protection is being extended to mothers who return and for 6 months after their return. So we don't know what the exact detail of that legislation is going to look like. It's with everything. If you have a legitimate redundancy situation, and as long as the reason for that redundancy is not somebody's pregnancy or the fact they've been on maternity leave, and it could still be classed as a fair dismissal, then yes, potentially, but there will be caveats. So at the moment we have caveats, for example, for those who are on maternity. They have to be given first refusal of suitable alternative roles that come up. So I imagine it's going to be something more along those lines rather than a blanket, no, you cannot make somebody in that situation redundant, because obviously there will be commercial decisions that have to be factored in. And if a business was ceasing to trade, for example, you couldn't possibly keep a person on just because they'd only just returned from maternity. So I think the protections that will be extended will ensure that there are additional rights given to those returning from maternity leave, rather than just a case, no, you can't be made redundant. I don't think you're going to be ring-fenced and have quite that level of protection, but it will be an extension of the rights that are already in existence for a longer period of time, and potentially enhanced rights as well. So ensuring that there's no possibility of unfavourable treatment or being treated less favourably, but no, it's not going to stop a redundancy scenario that is a truly legitimate situation. That would still go ahead as planned, as long as the reason for that person being identified as having a role at risk was not the pregnancy or indeed the fact that they've been on maternity.
Excellent, thank you. I actually think that's all the questions answered now. So we are here to help. So upon reflection of today's subject, if you do have any further questions, the next slide will provide our contact details. Alternatively, speak with your usual Azets representative if you're a client of Azets. As I said earlier, we will be sending the slides across to everybody, all participants from today, so please keep an eye on your inbox for these. And this brings our session to a close. So I'd like to take this opportunity to thank Hannah Jane and Sam for their presentation today, which was excellent, and to all of our participants for listening and participating in the poll questions. Have a good afternoon.
Thank you.
Thank you.
Thank you.